I'm delighted to be joined for this Zoom call by David Smith, landlord and tenant solicitor at JMW Solicitors, and also much valued contributor to Property Tribes and, of course, the wider property community with all the work that he does on behalf of landlords. And David, it's great to talk to you because we've had this new possessions ruling come through in the last few days, and I have a little suspicion that you might have been behind it.
Well, I'm not behind it in the sense that that might be assumed. I'm behind it in the sense that the government rushed it in because of something I was doing, which was threatening them with a judicial review for unlawful behaviour. But I'm certainly not taking credit for the regulations themselves or the terrible drafting and the weird way they've turned out. So I'll take some credit. How about that? A little bit of credit.
Well, I will give you credit for at least, making them do something. I think it shows potentially that the judicial review is a possible way to challenge them. We could talk about that in a minute to see if you've got plans for any more. But this came out. I think you gave them a week to reply to your intention to launch a judicial review. They came back and said, give us 2 weeks, and then at the kind of 10-day period, they suddenly came out with these new changes to the legislation. Very, very quick. What is your take on, have they conceded much ground?
I don't think they've conceded any ground. In fact, in some ways, the regulations are slightly worse than the previous position. It's probably worth going back to the beginning, and because some people were saying judicial review, what judicial review, and so on and so forth. So this all really came about because, like most people, I kind of assumed that when the courts opened up at the end of September, they would open up across the board. And I didn't think there'd be a big cliff edge of evictions. I rather thought it would be more like a lumbering behemoth slowly clunking itself into action and stretching its long discarded limbs. And that sort of started to happen, albeit even more slowly than we'd expected or hoped for. But then it suddenly emerged that in areas of local lockdown, which at the end of September were broadly speaking the northeast around the sort of Tyneside area, and the northwest around Liverpool area, bailiffs simply were declining to execute warrants. And the government had made an announcement had appeared. I'd seen a speech from Robert Jenrick, the Secretary of State for MHCLG, in which he said evictions wouldn't be happening in local lockdown areas. And I was like, well, first of all, I thought, okay, fair enough, I'll look out for those regulations. And the regulations didn't appear and they didn't exist. I started looking more closely at all the different coronavirus regulations. I realized there were no regulations. And it became patently obvious after writing to one of the bailiffs on behalf of a client, they turned around and said it was HMCTS policy. And they cited the speech of Robert Jenrick, the same speech I'd already read. And I was thinking, like, well, on what basis does a court bailiff, who's an officer of the court and has statutory duty and a common law duty, actually, as an officer of the court to execute court warrants and orders, on what basis does he choose not to, based on a speech by a Minister of State from a totally different department? I mean, if it was the Lord Chancellor speaking for the Ministry of Justice, you'd be halfway there, but not a totally different minister. So it became obvious that all of this was being done unlawfully. And then what then emerged, and my former colleague Giles Peake has written about, has got a lot of this up on the Nearly Legal blog as well. The High Court Enforcement Officers Association actually publicised some of the letters they'd had from the Lord Chancellor, which were broadly along the lines of, please ask your members not to enforce High Court writs either. So I couldn't see what had been written to bailiffs. The bailiffs' offices wouldn't give me the guidance that they'd received. They refused to give it. The NRLA had asked MHCLG for it and had been knocked back. And then these letters appeared from the High Court Enforcement Officers Association, so you kind of knew what was being said. But that's just not legal. And then I had a group of landlords I was talking to who'd come to me one way or another, mostly independently at random. I sort of stuck them together and said, well, do you want to pursue a judicial review challenge? And they were interested, but the problem with these things is that obviously I couldn't guarantee that we would win, although I was more somewhat hopeful. But and I was happy to do it on an at-risk fee basis, so I wouldn't get paid unless we won. But if we lost, of course, they would be liable for the government's legal costs, and that was a bit of a problem. So what we eventually agreed is that we would start by writing a letter and see if that brought forward a larger group of landlords who might then be prepared to split that risk among themselves. I had then spoken with some mortgage lenders and other people who were affected by this who were potentially interested as well. So the letter duly went off on a Friday evening, partly on the promise from a national newspaper of an exclusivity deal, which never transpired. The government got a week to respond. The pre-action protocol allows them 2 weeks, 14 days, but we gave them a week because we wanted to get on with this because it was quite urgent. They acknowledged this letter on, I think it was the Monday or the Tuesday, and said, well, we won't be responding in a week. The pre-action protocol gives 2 weeks. We'll respond in 2 weeks. And then, as you know, a set of regulations suddenly appeared. I still never actually had a response to the letter, but I expect one will appear tomorrow or Friday, which broadly says, well, it's lawful now, so off you go. And that kind of shoots at least the argument that was being made there down, because the argument essentially is that government ministers have no right to decide which court orders get enforced or not enforced. I mean, if that was the case, then you don't really have a rule of law anymore, do you? You have a rule of fiat by government ministers. It's up to Parliament to decide if bailiffs can't enforce warrants and writs. And fair enough, Parliament's now made that decision in effect by having a statutory instrument signed by a minister that goes before Parliament. I mean, clearly MPs haven't spent a lot of time looking at it. But the principle holds that they have, in fact, seen it, which kind of shoots the whole thing down, at least for the moment.
Well, that's quite an extraordinary story, David. I think obviously we are in a pandemic, and the government is responding right, left, and centre to all different sectors, which must be incredibly challenging. But do you feel that they have been fair with certainly the landlord side of the private rented sector? Because to my mind, it seems that there's been a lot of things put in place to support tenants, but far less so on the landlord side.
Well, I mean, they haven't put in place loan schemes or support schemes as Scotland and Wales have done, and I think that's going to be problematic as we go forward. Eventually, that's going to come home to roost. But I think the real problem, it seems to me, is not that. It's the chopping and changing. It's the constantly moving position. You have a court stay, and then it gets extended for a month, and then it gets extended a bit more. Well, extended for a few months, and extended by one more month, and then we're told it's going to be back with some new rules which are not very clear. And then you're told, oh, but even if you do get a possession order using the new rules, we won't enforce it in these areas, or in fact anywhere now. And it's this, and oh, notice periods are changing as well. Oh, and we're going to change them again. Oh, we'll change them a little bit more. It's this constant lack of direction that I think is the most damaging aspect. And that applies, I would say, across the entire response to COVID. But I think that it's also symptomatic in the PRS of the fact that the government doesn't actually have a plan for the PRS. And other things that have come into the same mix. EICR is coming into effect during COVID. Just doesn't seem very sensible to me. So it's kind of this issue of not really having a plan and constantly chopping and changing. And for example, the position of residential licensees who weren't protected by the original notice changes, and so the government started messing around with the court stay to fix that. And now, ironically, the new regulations don't allow any eviction. They do allow eviction in certain cases for ASTs, but if you're a residential licensee, you can't be evicted at all. So they've ended up with more protection than anybody else, simply because the government doesn't really understand the legislation they're trying to deal with, and keeps sort of changing its mind about what it wants to do.
Well,
I mean, the only upside of the current regulations is we know what the position is until January the 11th. There's no real prospect of it chopping and changing that much.
well, I hear what you're saying, David, because obviously I'm on the forums every day, and even I'm confused.com about things that are, going on. It has chopped and changed so much. So as we stand, today on the 18th of November 2020, what is the position for landlords that want to serve notice on a tenant using a Section 21?
Well, Section 8 and 21 notices haven't changed as of where they were a few months ago. So Section 21 notice is a 6-month notice. A Section 8 notice, it depends on what it's for. So the notice period varies. For rent arrears, it will be 6 months notice, unless the rent arrears are more than 6 months, in which will be 4 weeks notice. There are shorter notice periods for antisocial behaviour. You can then go to court. It will be slow. It will take a long time. There are various procedural things. If you've got a court order, you can't do anything with it. You'll have to sit on it. Unless your rent arrears are really high, you won't be able to do anything with it until the 11th of January. And after that, it starts to become really uncertain, because these regulations on banning evictions stop on the 11th of January, at which point presumably the bailiffs will start evicting people. But not in tier 2 and tier 3 lockdown areas, I assume, although no regulations have been passed in that area yet, but that's what the government was originally saying. And then in theory, in March, of course, things are meant to go back to the way they was. But I don't know if they will. We're all very excited about this vaccine that's going to appear, but the reality is that I can't get a flu jab just now on any circumstances, and that's not a terribly controversial vaccine. Even if there's a vaccine available, it won't be in mass production across the country by March. It's not very likely that everyone will have got it. So I don't know on what basis we'll be proceeding in March. I can't see that the government's going to open everything up in March and throw the doors open and say, woohoo, it's all done, because it won't be. So I guess then you get to a position of are you still then going to provide enhanced tenant protections or not at that point? And I can't see that they're not going to end up having to provide enhanced tenant protection for a bit longer. And then you get to this position of just how much longer can the landlord community hold on and hang on? I mean, they've no doubt had, many of them will come to arrangements with mortgage providers and all the rest of it, but it can only go on so far. And of course, people who want to sell will want to do so by March, because the SDLT thing will be kicking in. Will the government extend that? If they do, they'll probably do it at the last minute. So that's untidy as well. You're going to have a complete nightmare as you head towards March, with people desperate to get their completions through. So it's all these things intersect in a really untidy way, and no one really knows the answer, least of all me.
That is the whole thing about the private rented sector. It has so many moving parts, and there's so many knock-on effects. If one thing is tweaked at one area, then it can have collateral damage in another area. And I think this is something that the government has never fully understood. I mean, if we just look at Section 24, for instance, that was introduced in 2015 and is starting to really impact landlords now. And as you say, a lot of landlords were already struggling to hang on before all of the COVID additional problems that have been caused. And there's we're hearing stories of landlords with very, very significant arrears and really,
and the
really
Treasury's got to raise more money, and what they're going to do, they've already talked about CGT. That probably means that almost all remaining CGT breaks will disappear, except possibly principal private home, which will probably impact on landlords who want to sell. I think you are going to end up having the Treasury looking again at tax relief for landlords. For example, if you incorporate, you could still have your mortgage interest relief. I could see that disappearing, because it's an obvious way to close off a little bit of a loophole and rake in a bit more cash. There's inevitably going to be another look at second homes, and that includes, by definition, rental property. And I think the government will look at it again. I can't see any circumstance in which they're not going to do something that's going to, in some way, even if it's in quite a small way, have a tax impact for the private rented sector.
Well,
because
no,
I mean, the fact is they need the money.
well, I know.
They've spent the money. You can't not get it back.
No, well, there's definite headwinds to come, more headwinds to come for landlords. But I think there is a feeling within certainly the property tribes community, probably the wider landlord community as well, that the government is really just pushing back on landlords to solve housing issues during the pandemic by all these measures to stop evictions, etc. They don't want to have to deal with, we've got already, talk of council house waiting lists doubling by 2021, not enough social housing. It's almost like the government is pushing back on landlords and saying, it's your problem, you sort it out for the foreseeable future. And clearly, that's not equitable to landlords.
It's a difficult one. I mean, the government would say it's not up to the government to provide a living for landlords, but if you're going to bail out one group, then why don't you bail out another? I mean, there's the ironic thing about furlough, for example. In some cases, furlough has been enormously beneficial to companies who have managed to reconfigure their business while not paying a wage bill. And effectively, the government is bailing out certain organisations, albeit indirectly, to reconfigure their businesses. But the furlough scheme for other businesses is totally unhelpful. If you're self-employed or you're paid largely on commission, for example, these things don't do so well for you. And some of these people I've had other support schemes, but they're all a bit patchy. So, if you're a landlord and your primary income is from rental property, you've got a major problem. Then there's no real way out of that.
Well, indeed, and not only that, David, that some of the tenants that are not paying their rent are in receipt of furlough wages. Yeah,
so it's very difficult to get and pass on. And of course, the other problem is you'll be facing a tax bill, which may well be artificially inflated in a sense, because it'll be based on receipts up till the end of the tax year, which was really mostly before COVID really got going. And you won't have had money coming in since. So unless you put that money aside at the time to pay your taxes, you have real difficulty paying your tax bill. So it is a difficult situation. I don't know if the government's going to come under pressure to do something about tax deferment in January, but I can see people trying, but I can't see them really assenting to it because they need the money.
Well, lots to happen then in the new year as some of these emergency measures are unwound and we start to see the impact that they've had as they're withdrawn. So,
and then you've got Brexit kicking in as well, and of course the tenants reform bill, which is the renters reform bill, sorry, which is still slated to appear at some point in the spring. So there's still lots happening. Leaving aside the minor infection raging around the country, we've still got a lot of other stuff to deal with as well.
Well, we sure have. We're lucky that we've got you on our side, David. You mentioned before we started the call that you think there may be a call to start another judicial review. Are you able to tell us anything?
Well, I've been emailed by a couple of people who want to try and judicially review the entire scheme for some of the reasons you set out about the inequity and the lack of justice. I mean, it's difficult because it's one thing to go after the government because they've actually done something that is plainly and obviously beyond the powers of a minister. Any other argument would have to be based somewhere around human rights, and obviously the government has a considerable amount of leeway in the case of a national pandemic as to which human rights it starts to abrogate and to what degree. I mean, obviously there are limits. You can't start killing people. So there are certain human rights that you're not going to get away with abrogating, but the right to control over your property is a human right that is qualified. And it's difficult to argue that the government can't qualify it. I suppose what you have to do is argue that the level of qualification is too much for the circumstances, and that becomes quite a strong matter of opinion as opposed to a matter of law. That's quite difficult to argue. in judicial review, because it's also an area judges don't want to go, because it starts turning the courts into it starts to erode the distinction between the courts and Parliament and the executive, and that's, generally speaking, despite the comments of the government saying about activist lawyers and activist judges, in general, that's not somewhere the courts like to go if they can avoid it.
Well, I think we're very fortunate to have you, David, and also Giles Peaker, another landlord and tenant solicitor, keeping your eye on all of this legislation and, you know, in essence, holding the government to account. So thank you for what you're doing on behalf of landlords, and hopefully you'll keep us posted of any other plans you've got.
Well, yeah, we'll see what happens next. Something will come up, no doubt.
All right. Well, lovely talking to you as always, David. And thank you for joining me on this Zoom call to explain about your judicial review, how the government have reacted and how things might be going forwards. But definitely true to say, you know, headwinds coming to landlords, maybe even continue to be hurricane force.
Yes, I think so. It'll be a while yet.
All right. All right. Thank you very much, David. I'll speak to you soon.
Thank you. Bye-bye.